All right, in this last video, we're going to talk about labor laws. Probably the focus is going to be on unions, the establishment of unions. In the 19th and early 20th century, workers began to join together as unions and fight for better working conditions. But initially, courts treated any coordinated effort by workers as a criminal conspiracy. They convicted workers for the act of just joining together even if no strike took place. But with the collapse of the economy in 1929, which led to the Great Depression, public sympathy shifted to the workers, and Congress responded with the establishment of the National Labor Relations Act. The National Labor Relations Act, in essence, Congress put an end to any notion that unions were inherently illegal. So the NLRA ensures the right of private sector workers to form unions and encourages management and unions to bargain collectively and productively. Section 7 of the Act guarantees employees, except supervisors, the right to organize and join unions, bargain collectively through representatives of their own choosing, and engage in other concerted activities. And supervisors are defined as anyone with the authority to make independent decisions on hiring, firing, disciplining, or promoting other workers. So this does not apply to supervisors. Section 8 of the NLRA prohibits employers from engaging in the following unfair labor practices, and I will use ULPs, unfair labor practices. If you see that, I think they use that in the reading material. That's what that stands for. So interfering with union organizing efforts, dominating or interfering with any union, discriminating against a union member, and refusing to bargain collectively with a union. And Section 8 prohibits unions from engaging in these unfair labor practices: interfering with employees who are exercising their labor rights, causing an employer to discriminate against workers as a means to strengthen the union, and charging excessive dues. Other provisions of the Act include prohibition for requiring membership as a condition of obtaining employment. We call that, it's referred to as close shop. But it preserves the legality or requiring a worker to join the union after a specified amount of time on the job, which then we refer to as union shop. All workers become a union member, so then this organization is, so the employer is considered a union shop. The Act also allows individual states to pass right-to-work laws, making it illegal for union membership to be required for continued employment. Labor unions today. Unionized workers earn 13.2% more than workers without union representation. They're more likely to have health insurance, paid vacation, and sick leave. In the 1950s, 25% of workers belonged to a union. Today, only about 10% do. Membership in private sector unions has declined from 30% in the 1950s to 6.2% now. Why do you think that is? Well, most states have passed right-to-work laws that permit employees in unionized workplaces to opt out of joining the union or paying dues. Some large employers have relocated to states with little union presence. The number of manufacturing workers has declined. Employment is increasing in industries such as services that have not traditionally been unionized, but then we have an example of Starbucks employees. They've been fighting to unionize around the country. Public employees are more likely to be unionized. We see this teachers, police, government entities, but they are not covered by the NLRA. Instead, state labor laws apply here, which tend to provide less protections. And I'm going to note a case from 2018. The U.S. Supreme Court in 2018 indicated that county and municipal employees, it was the American Federation of State, County, and Municipal Employees, AFSCME. Yeah. The Supreme Court ruled that public employees do not have to pay union dues as a condition of employment. This ruling struck down mandatory union fees for government workers, and this, the Supreme Court said, violates First Amendment, free speech. So how do unions organize? Well, under Section 9 of the Act, a validly recognized union is considered the exclusive representative of all of the employees, meaning employers cannot negotiate with individual employees. The union negotiates for the collective. Even if the worker doesn't want to be included or join the union or has paid dues, the union has a duty of fair representation for all. They're required to treat all members fairly, impartially, and in good faith. So how does a union form? The organizing process. First step is to campaign. Those who want to organize a union, union organizers talk with employees and they try to persuade them to form a union. This organizing cannot interfere with their work. Employers can present anti-union views to its employees, but it cannot use threats or rewards to defeat a union drive. Step 2 is for those organizers to collect authorization cards. So the union organizers ask workers to sign authorization cards which state that the particular worker requests the specified union to act as her sole bargaining representative. If a union obtains authorization cards from a sizable percentage of workers, it seeks what it's doing is it seeks a recognition as the exclusive representative of the bargaining unit. Bargaining unit is all the workers. So the union may ask the employer at that point to recognize it as the bargaining representative, but not surprising, most of the time employers refuse to recognize the union voluntarily, which is what's happening with Starbucks or has happened with Starbucks. I'm not exactly sure where that is in the moment. So step 3 is the filing of the petition. If the employer does not recognize the organizing members as a collective unit, the union organizers petition the board of the National Labor Relations Act, there's a board, for election. The union submits authorization cards signed by at least 30% of the workers. The board verifies there are enough valid cards to warrant an election. It also ensures that the bargaining unit is a quote-unquote group of employees with a clear and identifiable community of interests, which generally means we have employees of similar skills, duties, and their pay are similar. If these are met, valid cards and a group of clear and identifiable interests, the board orders an election. The board will also supervise the election to ensure that it's fair. So if the proposed union receives a majority of the votes, the board will certify that the union is the bargaining representative of all employees. So now we have a union. It's certified by the board. The union will be authorized to negotiate with management on behalf of the workers in the bargaining unit. And collective bargaining is the process by which labor and management negotiate the terms and conditions of employment. The National Labor Relations Act permits the parties to bargain almost any subject they wish, but it does require them to bargain wages, hours, and other terms and conditions of employment, like healthcare. There's some other, the main ones are wages and hours, but they could bargain anything that they think of or that's related to their particular work. An employer cannot unilaterally make changes in the areas of wages or hours or what has been agreed to without first bargaining with the union. Conditions of employment generally include benefits, the order of layoffs and recalls. Somebody's laid off, who gets recalled, like how the recalls of coming back to work are, production quotas, work rules, retirement benefits, on-site food services, and prices. The union and the employer are not obligated to reach an agreement, but they are required to bargain in good faith. What we mean by that is the two sides must meet with open minds and make reasonable efforts to reach a contract. But sometimes good faith negotiations do not lead to an agreement. So what happens? Well, the NLRA guarantees employees the right to strike, but with some limitations. When no agreement is reached, the union calls a strike. A union can call a strike to protest an unlawful labor practice or to preserve work that the employer is considering sending elsewhere, but it has to be called by the union. Workers can't act independently. So what is a strike? This is where the workers refuse to work. And a collective bargaining agreement can include what's called a no strike clause, which a lot of them do. Think about teachers who have to work during a school year. If, God forbid, they called a strike right in the middle of the school year, then children wouldn't be taught. So generally in teachers' union contracts, there's a no strike clause, and that is something that employers will usually want in an agreement, a collective bargaining agreement. Picketing is not the same as a strike, even though they kind of come hand in hand. The goal of picketing is to discourage employees, replacement workers, and customers from doing business with the companies. So they, stand the line, or they standing out front while they're strike. They're not at home, sitting at home, I'm not working. They're out at the employee place with signs, and if a company hires replacements, they're trying to discourage them not to participate with the company. This is a lawful practice, but it has to be peaceful. You couldn't block the way for a replacement worker trying to get in the building. So that would be prohibited. Kind of like peaceful assembly under the Constitution. And our last component here is lockouts. So when negotiations are deadlocked and they've pretty much turned belligerent, management may engage in what's called a lockout. So this is the employer, right? The employer side. Managements prohibit workers from entering the premises and earning their paychecks. So workers find they get there, the doors are locked, there's armed guards when they get to work. So the idea behind this is that withholding work and wages, the company hopes to pressure the union to bargain less aggressively. So most lockouts are considered legal. And so this is the end of our discussion on the employment laws.